Little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. Sparking revolution, it's a truth-telling tale.
Hey, y'all. Welcome to Loud Little Ducky. I am back for my first live since I have been down and out. So we will get to David Gingras in just a moment. I'm going to remind y'all to make sure you're participating, comment if you're on replay. It lets the algorithm know that, hey, we're talking about fun stuff. Come check it out. And I always like to hear your thoughts and opinions. And if you subscribe, you can turn those notification bells on so you will never miss a video. You can also find me on Twitter at Loud Little Ducky, where I do post pretty much when I'm going live and when there's new videos as well. If for some reason your YouTube does not want to let you know about it. We also have memberships. I have recently put the code for 10% off of merch when you are a member of this channel. Also, exciting news, we hit 1K. So we are now monetized. So that is exciting stuff over here as well. And as for my health, I am doing much better. I did have a little scare on Sunday, but everything is okay. It wasn't as crazy of a deal as I thought, but it was concerning considering what I had been dealing with 2 bouts of hospital stays and so forth. But yeah, I am not a person in great health a lot. But everything is worked out. I've, gotten my antibiotics, I've gotten things under control and numbers back down to normal. And so hopefully things will stay that way, but I'm sadly used to it. I've been dealing with health problems for quite a long time, and it's an array of them. And they are kind of like invisible things that if you just look at me, I don't look like I have anything wrong with me. I would be a person that maybe a so-called Karen, if for some reason I had a handicap placard or wanted to use a motor scooter or something, they would look at me like, what is that bitch doing on that? Like, she looks perfectly fine. She can walk. She can do these things and all of that. But when you have autoimmune stuff and other things like that, it's all internal and you don't get to just see it on the outside. But we handle things. I'm sadly used to them, but if I can get to where I can like somewhat function every day, then great. And I, of course, never wish for anybody ever to deal with what I deal with. It's part of the reason I chose my career as a massage therapist is to help people not ever feel like I feel. But enough of that. We are here because apparently, while I have been gone, Gingras has been blogging up a storm and he cannot keep his mouth shut. He apparently is not like doing the Twitter thing, and he's not, from my understanding, doing the um, blue sky thing, but he has definitely taken to his law firm's website. Now, a thing that I wonder about, which if he is disbarred in Arizona, then his his law page website, I guess, would still be okay to have because then he would still technically be an attorney in California. Um, but will he just step away from the career altogether once he's done with Arizona? Who knows? Or will he keep his law page up? But then the question becomes is if he steps away completely, will he delete his law firm's webpage? Or if he gets disbarred everywhere due to things that happen in Arizona from what I believe is going to happen in the end, is it proper for him to even have a law practice website and a blog because he's a former? I guess it would be okay if he put on there that he was a former attorney and a non-practicing, doesn't take clients, that type of thing. Um, but that was just something I was thinking about. But we also know that he likes to be hacked or take things down, act like maybe he didn't do it because he was hacked, or that he just takes things down because he either regrets it or gets tired of people commenting on it, or whatever his reason is to try to delete things and act like they never happened. But the internet is forever. So while some of his stuff really doesn't have much to do with anything related to like Owens or JFC necessarily, he can't seem to leave everybody out of his examples. And he seems to think that he is just the all knowing David. He is the most ethical lawyer to ever exist. And everybody that's gone against him that has disagreed with his view on things, whether it's the state bar, the Supreme Court, a judge, other attorneys, laypersons, pond scum, that he is better than all of us. And if he's what's supposedly the best, I don't want to be anywhere near that. I want to be as far away from anything that he agrees with as possible for the most part. And so, first thing we're going to look at is today's blog. And then we'll look at some other ones and see. But first, welcome to the pond, mispronounced name for becoming a YouTube member. I am sorry for any of you that are also dealing with autoimmune stuff. It's just horrible. I have not watched his video. And because he does like to copyright strike people, I will not view it with y'all. And it's really hard. I mean, I could go through it and take notes and then rant and go on one of my little ducky ranting things, but do I want to take the time to watch that? Because he's a dumbass. And a lot of what he says is not really important, and his opinions a lot of times don't make sense and they're not really based in reality. And his view on things is sorely mistaken on a lot of things, which is partly why I want to take a look at today's blog because it is somewhat interesting. And sadly, he does bring Woodnick's name in his mouth. But um, so let's go ahead and pull that up. Mm, you know what? Let's see. Is this there we go. Let's put a Thanksgiving thing up, a November type background because, it's Thanksgiving. Oh, that's true. We give him the traffic. But does he get paid for the traffic on his website? Because that's another thing. I don't want to give him the views if he gets paid. All right. So let's present, share screen. Okay, we're going to make sure there's no audio on that. Okay. All right, let's see if we can make this a little bit. I don't think I like that one either. Nope. We'll just go to this. And hopefully that's good enough and y'all can see it. I wonder if we'll just do this. Okay. I want to come up with better layouts, but I don't know how to do any of that. Okay, so today's blog is how not to practice law. HNTPL. Okay. Like, I guess he's trying to make acronyms happen, which he's not good at. But okay, moving to withdraw. And that is interesting to post today because we know that Laura Owens' criminal attorney, Josh Colsard, whatever his name was, withdrew from Laura Owens' criminal case. Mispronounced name, as soon as you figure things out, let me know, because does that make a difference? Like, is there ways to make him look dumber than he already is? I mean, he does a lot himself. All right. So, from the most ethical and best attorney that is to ever have practiced law is going to tell us how not to practice law. And he says friends. Maybe they're imaginary. I don't know. I was in court this morning. I wonder where he was in court. Was it for his own case? Was he there with Owens? Because I don't remember any reportings or sightings of him. But it says, on my way in, a security guy asked the woman behind me, "You here to get married?" "Yes," she happily replied. Ever the joker, I had to drop this. "I'm here to get divorced. Don't do it, girl." Oh. So this is his announcement to his divorce, I guess, which good for the former Mrs. Gingras. I hope you had a huge party by getting rid of this guy. I smiled and explained that was a joke. I told her I was a lawyer and I congratulated her on getting married. You're so funny. The security guy, who was bald and probably 65, heard all this. He then looked at me and said, I used to be a lawyer 20 years. I got out and never looked back. We shared a couple of quick stories and I moved along. People always bragging about 20 years as being a lawyer. And now, okay, why did you need to say he was bald? Like, who cares? Okay, maybe you want to say 65 years old, but why is the bald need to be in there? That has nothing to do with anything. The exchange got me thinking about how people enter and leave the practice of law. Leaving is pretty easy. I know many former recovering lawyers. I'm about to be one of them. Yeah, there's some other things you should be recovering from, like alcohol, but you know, you're not doing any of that. But this reminded me getting into law is hard. First, there's a test to get into law school, the LSATs. Once you're in, lots of studying/work. Then there's a bar exam, the ethics exam, MPRE, and of course, the background check called character and fitness. Well, I guess because you didn't have criminal charges on you, but your character is awful. Plus, a law degree can be crazy expensive, way over 100,000 and often closer to 200,000 for tuitions, books, rent, plus 3 years of lost income. Once you graduate, then the really hard work starts, trying to learn the practice of law. You have a basic general background info from school, but new law grads are not even remotely ready to handle their own cases. Mastering the rules, procedures, and local practices is a massive task. It took me easily 10 years before I was comfortable handling cases from day one to final judgment. I don't know that it should take 10 years for you to handle a case on your own like that, but maybe, unless you're talking about from law school to then and you include law school and all that in the 10 years, but 10 years out of practice, I don't know that it should take 10 years to get the hang of things. And I'm not really sure you have the hang of things as of right now. Yeah, I hope she has a favorable prenup. Along the way, I got lots of help from older lawyers. Many people don't know this, but there is a strong tradition in our profession for older attorneys to help younger folks learn the trade. Mentoring is common and badly needed. I would like to talk to some of your mentors, sir, and find out what they think of you now. And did they teach you all the nonsense and garbage that you spew today? Is that stuff you learned from them? Because how embarrassing. As I am about to exit the practice of law, I wanted to share some pearls of knowledge I picked up along the way. I intended this to be purely educational. The goal is to help people learn the right way to do things, which will include showing them the wrong way. As my first entry in this series, oh boy, he's going to show us all this series of things he's learned. I want to talk about the first thing most lawyers file, a notice of appearance. Okay. I appear, therefore I am. This may seem beyond obvious, but when you want to represent a client in a case, you first need to appear for that client. Why? Because the rules say so. Every court is different, but in federal court in Arizona, local rule says a lawyer cannot file anything in a case unless they formally appeared. Does California say that? Because you seem to want to file things in cases that you are not appearing in. And then he cites the thing. No attorney shall appear in any record, file any action without appearing as counsel of record. An attorney of record shall be deemed responsible as attorney of record in all matters before and after judgment until the time for appeal expires or until there has been a formal withdrawal from or a substitution in the case. He said, this may be hard to believe, but I've had cases where lawyers tried to slide into cases without first appearing. You mean like you did in California? For instance, maybe you're in court to argue an important motion. Rather than the opposing counsel, a stranger shows up and tries to argue the other side. Sure, they might be a lawyer, but you have no clue who they are, and neither does the judge. This is weird and can be uncomfortable. Yeah, like you coming in as an intervener. You're like, well, it was not as a lawyer, it was as an intervener. But you're a freaking lawyer and you know. To prevent discomfort, courts generally require you to file a written notice of appearance as the first thing you do. It's required, so don't even think about diving into a new case until you formally appear. It's just a one-page thing, so do it always immediately. Thank you for the basic of Law 101 that you learn probably before law school that you need to enter your appearance. But without David Gingras letting us know this, we might not have known ever about this rule. No attorney would have ever known without his great mentorship. Then he says, sorry, client, it's over. I'm out. But what about withdrawing? When things go south and you need to leave, is getting out as easy as getting in? Not always. It shouldn't be hard, but for some unknown reason, this is a mistake by noob lawyers. Many noob lawyers make, and it's totally inexcusable. The number one most important thing to know in this, when you move to withdraw in the state of Arizona or California, you must be extremely limited in what you say. Don't go into detail at all, ever. This is not just smart, it is literally an ethical requirement, and it can be malpractice depending on how badly you screw it up. So don't screw it up. Here's the problem. Let's say you have a client who is very difficult. All right, so since David likes to use examples, we're going to pretend this client is Laura Owens, okay? In our example, for his example. Imagine this client has failed to pay you for months. Yeah, Laura and her family have not paid this lawyer, okay? The client also lied to you or is otherwise guilty of bad conduct. So, not only did Laura Owens not pay her lawyer in this scenario, she also lied to her attorney. And she is actually guilty of bad conduct. She is doing things that the lawyer does not like and that are actually make her guilty. And now the lawyer has found out that Laura Owens lied to him along with not paying him in our imaginary scenario here. Welcome, CE Designs. They asked you for advice about how to murder someone and get away with it. God, I hope Laura Owens does not ask her attorney this in any example. You just don't feel right helping them anymore. Yeah, no. Let's hope not. When you move to withdraw, can you tell a judge, help, please let me withdraw. My client is a broke psychopath and I just can't deal with this madness anymore. No, but we can say those things because that sentence seems to be exactly how Laura Owens and anybody that deals with her in law, that's their tagline. Let me withdraw because my client is a broke psychopath and they cannot deal with the madness of Laura Owens anymore. In our example, okay? David likes to use examples. We use examples here too. No, you cannot do that. You cannot go tell the court that. The reason in both Arizona and California is an ethical rule called ER 1.6. I have written about this rule before. See the Arizona bar's odd and incorrect obsession with ER 1.6. In Arizona, the state bar views ER 1.6 as an extreme and unlimited restriction, which limits a lawyer's ability to say anything without client consent. In Arizona, the bar believes ER 1.6 prohibits a lawyer from even mentioning the client's name or any other detail about their case unless you have consent. I don't agree with this view, but that's how Arizona sees it. Well, you don't agree with anything that anybody says. You hate everything that Arizona laws stand for now because they don't like you anymore. California is far more chillaxed with this stuff. California has essentially the same rule as Arizona, but the wording is totally different. What about Florida, Gingras? What is Florida's rule on it? Because in this, something that I want to look at is, or maybe sorry, maybe we will not look at it, but Sarah Boone had many lawyers withdraw from the case. And so, did any of Boone's lawyers that withdrew do things or say things to the court when they were withdrawing that they shouldn't have? Because instead of using Woodnick, although he's like, well, it's Arizona and California I practice in, so I didn't want to use a Florida example. But that would have been a plethora of examples to take just from one case to say, hey, these are the lawyers that did it right and followed the rules, and these are the ones that didn't. But no, he has to say shit talk attorneys and people that he considers JFC and his mortal enemies. So he brings up the State Bar of California, Rule 1.6, confidential information of a client, rule approved by the Supreme Court. And that rule has been effective since November 1st, 2018. A lawyer shall not reveal information protected from disclosure by Business and Professions Code, Section 6068, Subdivision E1, unless the client gives informed consent or the disclosure is permitted by paragraph B of this rule. And then you can click on something here. To recap, Arizona takes the position that ER 1.6 restricts a lawyer's ability to say anything about a client without consent. But in California, the rule only restricts disclosure of information covered by the California Business and Professions Code, which says a lawyer shall maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. So in California, only client secrets are subject to restriction under Rule 1.6, where Arizona, incorrectly, in my view, takes the position anything you know about a client is restricted by ER 1.6, which he did recently actually write something on that, which was somewhat interesting as well. Some of his stuff is interesting, and sometimes he does have coherent thoughts. I don't know why he doesn't ever put those into action in his actual legal practice. He just blogs about stuff, which if you would have put into action some of the stuff, like some of your sober thoughts into your practice of law in everyday cases, maybe you wouldn't be in the situation you're in. But Because of this, Arizona's position is clear. When a lawyer moves to withdraw, the only thing you are allowed to say is this: professional considerations require termination of the representation. That is not my view. That is the position of the State Bar of Arizona, Informal Ethics Opinion 902. You might have very good reasons for withdrawing, but you cannot go into detail. ER 1.6 absolutely prohibits that. Now that you know the rule, let's look at two examples of how a lawyer should withdraw. First, the wrong way, and then the right way. Full disclosure, in this example, I'm going to use the work of a lawyer named Greg Woodnick as an example. The reason is not a secret. I recently dealt with Greg in a high profile case, which he won. One doesn't need to be in quotations, sir. He won. Okay? You didn't, your client didn't. It's not a quotation. Nothing's going to change about that. No, he won flat. No quotations needed. Along the way, Greg showed himself to be one of the most dishonest and unethical, incompetent lawyers I've ever seen. Well, then you must have no mirrors in your house. Because if you looked at yourself in the mirror, you would see someone 20 times worse. Those are my subjective opinions, of course. Yeah, and your subjective opinions are not based in reality. But given that the legal and ethical requirements for withdrawal are clear and unambiguous, let's take a look at Mr. Woodnick's work and see how well he did. So, for some reason, Gingras is stalking Woodnick's filings because why why is he following Woodnick's cases? Is he looking for a reason to pounce? Um, like, I just don't understand. So this says amended motion to withdraw as attorney of record for defendant without consent. And this is apparently in the Owens v. Gillespie matter. So apparently Woodnick wants to withdraw as the attorney of record for the defendant without consent from Greg. And let's look at this. In accordance with Rule 5.3A2B 2 of Arizona Rules of Civil Procedure, the undersigned respectfully moves the court for an order allowing Casey Bowman, Greg Woodnick, and Marcus Reisinger, and the firm of Woodnick Law to withdraw as attorneys of record for defendant Greg Gillespie. The reason for this motion is that a breakdown in communication between attorney and client has occurred, such that the attorney cannot proceed with client's representation. The client has failed to substantially fulfill an obligation to the lawyer regarding the lawyer's services and has been given a reasonable warning that the lawyer will withdraw, and the withdrawal can be okay. So he just puts that in there. Notice anything wrong here? Rather than complying with the mandatory ethical limit of ER 1.6, Mr. Woodnick went way beyond the rule allowed, totally off the deep end, and a perfect example of what never to do. This paragraph is one of the most objectively unethical and incompetent things I've seen in a long time. Well, maybe the without consent is not that he can't put in there that he can't pay his fees. Maybe it is that Greg doesn't want to consent to him withdrawing, not that he doesn't agree that to put this in here. Who knows? We don't know what Greg and that breakdown is. We know that Greg and Woodnick don't have a crappy relationship. But my guess is the reason that he wants to use this one is he's recently looked at all the filings in the Gregory Gillespie case because of Laura Owens' new indictments. And wants to be like, yeah, Woodnick was Gregory Gillespie's attorney, but Greg couldn't even keep Woodnick because he couldn't even fill his obligations to Woodnick. So while he's sitting here saying this is all Woodnick, it's a way to embarrass Gillespie. I think he has ulterior motives here because he's just looking through all these filings. Why are you looking through the Gillespie filings? It was before your time, remember? What why are you interested now about the Gregory Gillespie case when you haven't been before? It it is, but I think it is, Bruce, but I mean, I get what he's saying here. And it's funny that he sits there and he's like, "Oh, Woodnick is unethical and all this stuff and the worst lawyer I've ever seen in my life." But also Omar is bad as well. And I'm sure he says bad shit about the Florida people too, but he he also states that he agrees that Woodnick should be allowed to do those things because he doesn't agree with the way Arizona puts it, where you should just say, I'm withdrawing because of like kind of the way that Owen's criminal attorney withdrew personal considerations. And so he's contradicting himself here. But here to me, this is to one, bash Woodnick and talk shit about Woodnick because he likes to. But to me, it is also to try to embarrass Gillespie. To me, it also shows that Gingras is in the background looking at the Gillespie case, at least now. And is he in Owen's ear on all this stuff, trying to help her with these new indictments behind the scenes and just trying to give her advice as her bestie? Yeah. I just don't know why he wants to dive in now when those new indictments just came. But when he was a lawyer on the case and Gillespie was going to be a witness, he was like, "Oh, it's before my time. I don't give a shit about Gillespie." So, like Echoes from Tabernacle said, whenever David goes on blog rampage, the question I like to ask is what is he trying to distract us from? And I agree. There are little hints and treasures and stuff that he puts in these things, kind of like secret, subliminal, hidden messages um, that are in them. Because there's a point, but the point to his ramblings are not always what he's talking about. Let's see. Let's see. The reason for this motion is that the breakdown in communication between attorney and client has occurred such that the attorney cannot proceed with client's representation. The client has failed, and he restates that. He wants people to know it's because Gillespie couldn't fulfill an obligation to the lawyer regarding the lawyer's services. And Greg had been warned about needing to fulfill those obligations to keep Woodnick as his attorney. On a scale of A through F, this one is an easy F minus. Well, F minus wasn't even a choice. You said F, which does not include F plus or F minus. An A plus included because it's A through F, but you can't say F minus when that's not even a choice, David. There's some Bruce logic for you. I like I like Bruce logic. Mr. Woodnick did exactly what the rule forbids. He threw his client under the bus by revealing way, way too much information. And as the motion notes, it was filed without client consent. No, I don't know that it was filed without client consent. I think he is withdrawing without client consent. Like Greg doesn't want to consent to Woodnick withdrawing because Greg wants Woodnick as his attorney. I think that could be read differently than what Gingras is implying here. When you don't have consent, you must shut the F up. But here you are. But I guess Laura gives you consent to be her motor mouth. Says unless you're talking about something that fits in an exception to ER 1.6. But you don't know what Gillespie consented to him putting in there or not consenting. It's just that Greg doesn't want to consent to Woodnick withdrawing. Yes, Moose logic is always A plus. Yeah. He could be jealous of Woodnick's interview with Law and Crime, but Gingras has appeared on things. He's appeared on A&E specials. He has appeared on Dr. Phil. So he has had media things in the past. Yes, did he reveal too much? DSG makes assumptions about filing. Assumptions are not literal statements. Yeah. He he doesn't know what the not consenting thing was. It doesn't say that Gillespie didn't consent to a damn thing that Woodnick said or did. Only Greg can speak. Only Gillespie can speak to that. There is no question Mr. Woodnick violated ER 1.6 when he filed this. He basically informed the entire world that A, his client was broke and failed to pay him. B, there was a breakdown in communication. This is common shorthand among lawyers, which shows the client wanted to do something against the lawyer's advice. Breakdown in communication just could be that Greg can't find a way to pay him. I don't know that I would like to think there is not anything that Gillespie was wanting Woodnick to do that was against that Woodnick was that Greg wanted because we're dealing with two Gregs, that Gillespie wanted Woodnick to do something that Woodnick legally couldn't do. Or that Gillespie did not want to take his lawyer's advice. I do not think that that's what that means, but he wants to put it in there because he knows that Laura has this stuff in there. Laura's attorneys have withdrawn because Laura wants them to do something against the advice. That's why I wanted to see the filing of the criminal lawyer withdrawing to see if it was financial, like maybe Laura couldn't pay the private attorneys anymore, or if it was like a breakdown in communication, or if it was because ethically there was a difference. And Laura wants the criminal attorneys to go up there and claim that she's pregnant. And the attorney is like, I cannot go up there and say that because you weren't. I mean, there's things that's why Sarah Boone would have been a good case to use as an example instead of this, because there were lawyers that are like, Sarah Boone wants us to do a lot of things that we ethically and legally cannot do in defense of her. So it says both of those things may be true, but under ER 1.6, Mr. Woodnick was forbidden from revealing that information without client consent, but he did. You don't know that he didn't have client consent to put that in there. He's like, "Hey, can we put this on there so that all this?" And honestly, I didn't actually know that Woodnick withdrew from the case and wasn't Greg's attorney at any point, um, or who took over for Gillespie after Woodnick and them left. If you know that information, let me know because I didn't know that. Again, this isn't even a close call. The State Bar of Arizona form of ethics makes it crystal clear. The withdrawing lawyer must protect the client's interests despite any dispute the lawyer and client and despite any wrongdoing of the client. Any disclosures of confidential information must be strictly limited to those circumstances authorized by the rules of professional conduct. The thing is if this is a rule, then what happens if a judge is like, okay, well, this rule doesn't tell me anything. Like, I'm going to need more of a reason than I just need to withdraw because there's something going on behind the scenes, judge, that I can't say. Is, can the judge not ask? Because the judge has to make a call because it- the judge doesn't have to let the attorneys withdraw off of a case. In a civil case, it's a little bit different. Family cases, a little bit different. But in criminal cases, for sure, the judge doesn't have to give permission to let an attorney withdraw. So, for the judge to make a ruling on whether this is something that the clients just need to figure out with their attorney or the attorney needs to figure it out with the client, they're going to have to give more information. And so, what happens if the client's like, no, I'm not going to allow you to give them information on why you want to withdraw? Is that just client difficulties? Like, there's gotta be a way to word things that's not actually giving information out. Maybe Woodnick did put something in here that maybe he did give more detail, but Gingras also said he agrees that you should be allowed to do that. But of course, Woodnick is unethical because he did it. I mean, does it make it right that the judge was like, didn't say anything to him about, hey, I'm going to let you withdraw, but next time you file withdrawal with this court, do not do this? No, there is no rationalizing with him for sure. No, you should never lower your standards, Bruce, never. Always be true to you. Let's see. So, now let's take a look at the right way. This happens to be from a recent California case I handled. And as noted above, the CA version of ER 1.6 is way more lenient. Even though I could have gone into a bit more detail, I decided to play it safe and use the AZ style method because I am the most ethical lawyer out there. So I am good, Woodnick is bad. As you can see, I went into a fair bit of extra detail to explain the issue to the court. Why did I do that? I did it because California changed its ethical rules in 2018 to more closely match the modern ABA model rules. Prior to 2018, the ethical rules in California were totally different. Okay, why does that matter right now? No, because of the changes, all that require okay. For example, the specific court, the federal district court in Los Angeles, had a very old local rule which required lawyers show good cause before they could just withdraw. I think that should be the rule. I think the lawyers should have to show good cause because people need to know. Let's see. That rule directly conflicted with the new 2018 rules in the case where good cause was based on secret information. For that reason, I took some extra time to make sure the judge understood why I was not going into detail about the reasons for my withdrawal. In short, unlike Mr. Woodnick, I understand the ethical implications of revealing client secrets, and unlike Mr. Woodnick, I chose to stay on the correct side of the ethical rule. Well, good for you. For once, you stayed on the ethical side. So apparently he was in a court case in California, the Blacklist Online LLC, a Delaware limited liability complainant, Shalon Doney, an individual, versus Adam Campbell and Matt Wagner. Notice of motion and motion to withdraw as counsel for plaintiffs. So he was representing the Black Online company who was suing two individuals. And this was back in 2023 before he completely went off the rails. To all parties and their attorneys of record, notice is hereby given that on August 2nd, 2023 at 10 a.m. or as soon as thereafter as counsel may be heard in the court of the above entitled court plaintiffs, counsel David Gingras will and hereby does move to withdraw as counsel for the plaintiffs pursuant to the rules. The motion will be based on this notice and accompanying memorandum of points and authorities and upon such and further oral and documentary evidence as may be presented prior to or at time of the hearing. The motion is made following the conference of counsel pursuant, which took place on various dates beginning on June 23rd, 2023. Okay, you just said you were withdrawing. Why did you withdraw? I would like to know why you withdrew in that case. Look, friends, being a lawyer is hard, but it's not that hard. Appearing in cases and withdrawing from cases is something every lawyer does, usually many times. If you want to be a civil litigator, make sure you check the rules and follow them to the letter. Well, you need to take your own advice, sir. Okay, just I want to withdraw. That's it. You don't even there's nothing else there as to why you withdrew. Hopefully the client you were withdrawing had better representation after you. What is this? That's why I would never talk to her with sideways pants. Yes, happy complex case management day, which we got new information, which probably means that the case, the criminal case is probably going to be continued. Because now the public defender that's assigned has to catch up on this case. And I don't know if 1.5 months is enough time to defend her on this case, even if they just do the Clayton Eckerd portion, first 7 indictments in one trial. And then they have more time for the Gillespie one. I don't think I would be shocked if there wasn't another continuance, and it will not be happening in January. That is my thinking on this. Yeah, I mean, he's dumb. Okay. Is there another one that y'all really want me to look at and give my thoughts on? In particularly, like a specific one. Let's see here. There's that one about that one lawyer. Let's read this one because this one seems to be about the bar guy. This one was posted on November 13th. Yeah, Jeanette Braun and David Gingras are they're both bad. Like, maybe Jeanette and David no. That would be awful for everybody if Jeanette and David got together, but good lord, are they not two peas in a pod? And they're both internet lawyers. Okay, let's look at this blog just because he is a dingleberry. All right. This is why we can't have nice things. November 13th, 2025. He likes to talk about Lauren Knighty in this one. Okay. Which, like, I guess because he has no clients, he has nothing better to do but blog, but like, find something else to do. Go find a hobby other than drinking. Yeah, the poor public defender. And we'll see if this public defender stays on or not either. Because is Laura going to want him or her to argue things that he legally can't do once he sees the discovery? All right. I am away from my desk today. Okay. Well, you still have means to write a blog, so apparently you don't need your desk. But someone just reached out to me to let me know about a comment that was posted in my site this morning. I don't think it was in your site, it was on your site. And maybe this is why you believe that there is hackers, because you think things are in your site. Like, there are no hauntings and ghosts in your website, sir. And if you think that, lay off the bottle. So he shows the comment, and it was basically a comment from the Invinchenko files that he put on there. And it says, bar guy Jim Lee, in my case, took a cash bribe of $50,000 from Andrew Invinchenko's law firm last week to rule against me in my current case, 27-1707. I have confirmed bank receipts. And then it looks like it's supposedly posted by Gingras. He says, I shouldn't have to say this, but I will. This comment is obviously fake, 100% false, not from me. Okay. The person who posted had an IP address of blah, 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 which I blocked from making any further comments. Great. What does that IP address have anything to do with us? Do we know your IP address? No. This comes back to an ISP in the Bay Area, California. I am sure most people know this, but it is very easy to use VPN to fake your IP address. So in theory, this doesn't even prove it was me, but it was not me. Of course, I'm sure Lauren has already screenshotted this and filed another complaint. Can't wait to see her and the podcast lunatic make 12 more YouTube videos about this. Jesus, girls, get a life. You get a life, sir. And actually, most of us don't even go through these things. There's just a lot. And so I'm like, let's see what the nonsense is. Because he's just on something right now. And why would Lauren file a bar complaint about something that's not related to her? Anytime Lauren or anybody else has filed a bar complaint, it is because you have done something to them. Lauren's not filing bar complaints based on other people's actions. They're your actions towards her, not your actions towards other people. My bar complaint I filed was your actions towards me or regarding me. I am not going to go file a bar complaint because Bob wanted to do something to you or you wanted to, it looked like you were pretending or lying or whatever about somebody else. Like, that's not how any of this works, and your arguments are stupid and unrealistic. But I guess believe what you want to believe, sir. But anyway, I don't have time for that bullshit today. Comments are off. And that's really unfortunate. Some people, a small percentage, but still, we're adding fair comments/questions. I can't sit here and police comments all day long, so no choice but to turn them off. That's your choice. You don't really need to blog about it. About you turning I guess maybe because, people question. But you've already you blog all the time about what you do with your comments. I'm turning them off because I only give them like 3 weeks or this many days or somebody hacked me or I'm turning them off because somebody's pretending to be me when it's not me. You saying it's not you and saying people can use VPNs and giving an IP address that means nothing to us. I don't know. This doesn't prove or disprove that it was you that wrote the comment. But maybe you needed to mention Lauren's name because you haven't in a couple of days or something. I don't know. For all you would-be pranksters, let me just remind you of something. The bar guy said he plans to file charges in the next week or two. That was like 10 days ago. So he should be filing the case soon. Finally. I'm glad you're so excited about this. The minute that happens, I get this huge gift. I will have subpoena power. That means I can force people to produce documents or hand over their phones, computers for inspection. Yeah, if the court says you can. I can also take depositions I need. I can ask Instagram/Twitter for info. Yeah, you can ask them for that. But they're not going to give it to you. They wouldn't give it to Blake Lively. They're not giving it to you, sir. I can unmask anonymous people if appropriate. See, none of it's appropriate. None of you trying to do any of this is appropriate for anything. I can't and won't abuse the power. Bullshit. Yes, you will. But I can do any discovery that seeks relevant information. As part of that, Mata will be getting a subpoena. 2, actually. 1 for documents and 1 for her deposition. Same with Mata's father. Same with Woodnick, Gillespie. Why would you need to subpoena Gillespie? What does he have to do with you? You weren't involved in any cases with Gillespie. Like, Gillespie was a possible witness, but you haven't dealt with Gillespie at all. Are you gonna subpoena Maricini? Because that'll be fun. Not for you, though. None of these will be good for you. I can't know for certain since I haven't seen the actual claims, so all this is to be determined. But I am entitled to defend myself, and I intend to do so vigorously. Why? You don't even want to be an Arizona lawyer anymore. And you can try to defend yourself, but your actions are indefensible. I need to get back to my other stuff. I'm sorry that childish idiots have forced me to turn off my comments, but hey, that's life. You sound like such a professional attorney on your law webpage. Like, if I was looking at this man's webpage, to see if I wanted to hire Gingras as my attorney, and I went and looked at this man's blogs, I would not be hiring him at all. Ronnie, I don't know. You think Janet is more evil? I don't know. I I don't think Janet's more evil. I think David is, but that's just me. Any of y'all agree? Or who do you think? Do you think Janet is worse than Gingras? Or do you think Gingras is worse than Janet? Let's see here. Okay. I don't know why he needs to pop this up. Okay, who is this? He's going to identify people. All right, whatever. And then that was the end of that blog. He's so ridiculous. So you think David is more dangerous, Jeanette is more evil? Jeanette is definitely more conniving and like planned, like premeditated type stuff. David is unhinged. And so I kind of think that unhinged is a lot of times can be more dangerous than somebody who's just planning things. Okay, let's see here. November 10th. State of Arizona lies, apparently. November 7th, Friday fun, let's feed the trolls. Yeah, David is a lolcow for sure. 1 second, guys. Sorry about that. My daughter is like, I don't know. My daughter was in here being suspicious. So I was trying to figure out why she's being suspicious and weird. But she's no, Jeanette did not get any DUIs. Jeanette is something. Echoes, do you know about Jeanette Braun? Because the Do You Know Me podcast girls, they're a good one to follow about it. Cece Suarez is another one who has done stuff on Jeanette. Ian Runkle is dealing with her currently. So he's been doing a lot of stuff. I think that Jeanette, whatever you want to call her, is dumber than David. Like, I think David has knowledge But and I think David does understand him, but I also thinks that he tries to twist everything, which is very lawyerly like of him, is to twist things to try to be his way. Um, and I think he likes to twist and abuse the law um, to fit whatever narrative that he wants to do, and tries to make him look like he is doing things ethically and by the book, and he gets mad at everybody who doesn't do things by the book. But to me, he's a criminal. And I'm going to say he's a criminal because he has been convicted of a DUI, and that is a criminal act, and so that is not defamation. He is a criminal. And he's under charges right now for more criminal behavior. And a DUI is criminal behavior. So there's that. Now, do we want to go with let's feed a troll? Or do we want to go with what is it? Is the State Bar of Arizona broken/corrupt? He says, yes, it is. Here's the proof. And he did an update to that after. Yes, Echoes. That is the attorney that is suing Runkle, or trying to say that Runkle is stalking her, even though he's never been to the state that she's in, or sometimes in, because sometimes where she lives changes. I it's She's a weird and crazy one too. I'm starting to think that anybody that classifies themselves as an internet lawyer is not okay in the head. Just my opinion, though. All right. So let's go with and it is always illegal to lie. This statement is a lie. So I'm guessing that's his opinions about perjury, I'm guessing. Mhm. That just like, of course, he's got to mention Trump in some of his blog posts. Not interested in that one. Let's see. All right. Well, that one's interesting too, but I think I'll do a video on that one since it goes with the appeals in the Owens v. Eckerd case. That'll just become a video by itself. Let's see here. What's this feed the trolls one? Because I'm guessing it has to do with us trolls. Oh, this is okay. This is the one that Lauren was talking about the other night. And I will have things timestamped down below mispronounced name so you can get some rest. So when we go to a different blog, since we're starting a new blog, it will be timestamped as this new blog if you want to start from here. So this is Let's Feed a Troll that Gingras did over. And Lauren was talking about this over on the Court of Random Opinion, that there was somebody who was basically trolling Gingras on his blog and making comments, but was using AI for the comments. So it ended up being Gingras actually arguing and now blogging about a robot troll. So he has beef with ChatGPT or Grok or somebody with this. So this one might be a fun read. Because I'm like I said, I'm way behind on a bunch of stuff that's going over, and I um I'm not even sure that some of my comments or things that I posted were even coherent statements on some of the stuff when I was hospitalized because it was drugged. It was drugged when I made comments. So, November 7th, 2025, he wrote this Friday Fun. And then on 11/7/25 at 5:35 p.m., he 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 closed the comments due to abuse. People were abusing the comments section. So he says it's almost never a good idea to feed online trolls. If you're lucky enough not to have encountered trolls, you may not give much thought to them. Lucky you. As part of my job over the last 20 years, I have necessarily dealt with tons of trolls. 99% of the time, you just ignore them. It's the only choice, but not always. Sometimes you try to fight them, always dumb, and sometimes you feed them even worse. And then he uses AI to give us what an internet troll is when someone posts inflammatory, offensive, or disruptive content online to provoke an emotional reaction in others. Trolls often use anonymity to harass, spread misinformation, and derail conversations for their own amusement or to cause harm. Their behavior is linked to personality traits like aggression and narcissism and can be in situational response to things like mood or the actions of others. Sir, you right here fit this definition, Gingras. Your personality traits of aggression and narcissism, and that you have situational responses to things that have to do with your mood and action to others. You You try to provoke emotional reactions. You definitely disrupt content online. You're offensive, and your posts are most definitely inflammatory all the time. You are the definition of a troll. You're not an anonymous troll. And but the thing is if you try to call JFC a troll, the thing is we do not spread misinformation. We don't contact people to harass them anonymously or using our names. And we are not over here derailing things for amusement or to cause harm to anybody. But you always are. Maybe not always, but a lot of times. I recently wrote a fairly boring blog post. Yeah, many of them are boring. Talking about a weird, obscure ethical rule, which I think the State Bar of Arizona has misinterpreted. Likely Lately, I have not allowed comments on blog posts because trolls are like mosquitoes this time of year. Why this time of year? Like it's because it's the holiday season and after Halloween, the online trolls come out for the holidays? No. That's not how this works. Apparently there's online trolls are seasonal, y'all. We do not work full time. Let's see. But an experiment this time, I left the comments open. I don't know why he wrote screen door and scratched it out. I guess that's a nod to his mosquito funny that he thought he laid. Here were a couple of other junk submissions which I removed, but the nice little troll called Bobby was kind enough to add his 2 cents. If you want to read the original unmodified version of Bobby's comment, you can find that at the bottom of the page here. Okay. For now, as an experiment, I'm going to share Bobby's comment with my responses as needed in bold. Bobby, TLDR. The latest blog post by David Gingras, an attorney known for his strategic manipulation of public narrative, is a textbook example of using a tangential legal argument to subtly influence the perception of his actual ongoing troubles with the Arizona State Bar. Is Bobby lying? GG. Wow. I didn't realize I was known for my strategic manipulation of public narrative. I guess you saw an article I wrote about global warming. I'm flattered you think I can or ever have manipulated the public narrative. This is a major aspect of what lawyers are hired to do, right? So you're saying I have done a good job at that? Thanks a bunch, Bobby. We're off to a great start. More Bobby. Although he explicitly states his commentary is not about his current disciplinary dispute, given his status as a known liar, the entire post is highly suspicious. Yeah, these sound like robot responses too. Like, it sounds just like something a robot would write, that AI would write. DG, oops, so much for a great start. I'm a known liar? Really? Care to offer any examples of this? And I'm sorry, you think a legal breakdown of an obscure ethical rule is suspicious? It's just a nature of debate. Don't be afraid, embrace it. Oh, but one tangent. Did you know it is a scientific fact conservatives perceive the world differently than liberals or anyone else for that matter? Everybody perceives the world differently, no matter who you are. My perception of the world is different from anybody else's perception of the world because I have only experienced the world my way, through my eyes, through my life experiences. Nobody else perceives it the way I do. So the fact that you want to say conservatives and liberals perceive the world differently, so does an ostrich and a bear. Why do you need to bring politics into things? This is why people don't like you. When you think about this explains a lot. My personal belief is those who hold conservative views are generally either not very smart, not very educated, or suffering from some trauma that causes them to see everything around them as a threat, even things that are not threatening at all, like a blog post about an obscure ethical rule. Sir, just because somebody chooses to write on a particular blog post about you doesn't mean that they're even talking about your blog post. It could just mean, oh, this is the most recent thing he put out. I'm going to comment here about what I think about him because there's no other way to contact him that the public can see because he's not on Twitter or other places. Okay. This has nothing to do with conservatives and liberals, but of course you just bring that crap into it. I know that's an aggressive statement, but this article lays out reasoning behind that opinion. Well, good for you. Maybe instead of reading psychology today, you should go to a psychologist yourself, David. And then he says, consider this quote. Conservatives see the world as a more threatening place because their brains predispose them from being fearful. They also are predisposed by brain biology to hating complexity and compromise. That would help to explain why politics can be so polarized, particularly in a rather conservative era like the present. Okay, so you don't like conservatives. There's some liberals that I know that I know them and I'm respectful to them. but I don't necessarily agree with everything that they have to say. We might agree on some things, but there's a lot of things that we don't. Um, Conservatives, there's probably things in there too. Like, I'm not well versed in all this. The only reason I know a little bit about liberal stuff is I know somebody who is considered very liberal or says they're very liberal. Um, but they're always starting political fights. So if you're a liberal, then that might explain some things because your way of talking politics is similar to some other people I know. Not that all liberals are that way, but I just don't understand what politics has to do with this. It's just very weird. Talk about hitting the nail on the head. Conservatives fear everything around them. No, not all conservatives. Um, that's just your opinion. So, like frightened children, they overreact and respond from position of fear, not logic. Close the borders, gas the protesters, imprison, kill reporters. Who said kill reporters? Who said that? Remove all brown people. These things are so scary. Nobody said remove all brown people either. Not even the people that say close the border say remove all brown people. That's a dumb statement. Anyway, I digress. That's a topic for another day. Let's get back to Bobby. Yes, let's get back to Bobby because I like Bobby. More Bobby. It reads as preemptive. Public legal brief designed to lay the groundwork for a First Amendment defense he is likely planning to use in his actual bar case. It does not sound like a person. Gingras, so it sounds like you're dumb. David responds, pains me to say this, Bobby, but for once, you're not entirely wrong. The First Amendment is still a thing. And it is absolute. And it absolutely is a thing I intend to use against the AZ bar. Is it really too much to ask the Arizona bar to respect the United States Constitution? When? Please tell me how the First Amendment, David, is going to help you in your bar complaint against with Mike Maricini and your behavior towards him. I don't think that's a First Amendment issue. Now, I can see him using it is his First Amendment right to write, look at me, Daddy. I'm a real judge now. Tee-hee. That's his First Amendment right to do that. And you would be correct, David. You have the right to write that dumbass statement in a legal filing. Is it professional? Is it ethical? No. Are you supposed to hold yourself to a higher standard in a court of law when addressing the courts and officers of the court? Yes. But you know what the Arizona bar is not? They are not sending you to jail over you saying statements. So they're not doing anything to hurt your First Amendment right. You have the First Amendment right to say it. You are not free from consequences of things that you say, though. But you would have an argument if the State Bar of Arizona was trying to put you in jail over things you said. They're not. So your First Amendment rights are not being violated by the State Bar. And as a lawyer and a person that's supposed to know about the Constitution, you would think that you would understand that. The Constitution is protecting you so that you cannot be criminally charged or criminally punished for your First Amendment right. So I guess you can try that argument with the state bar to save you, but it's not gonna save your license. So you're gonna lose your license. That's gonna be a consequence, but you're not gonna go to jail for it, and you can continue with your unhinged behavior of the mouth and your writings. And then if you ever get arrested for your words, then you can try to make this argument. But this argument means jack shit to the Arizona State Bar. That is that to me sounds dumb. Yeah, he doth protest too much with Trump. Definitely doth protest too much. Says, in fact, did you know all lawyers must swear an oath when they join the bar? Want to guess what the very first line in the oath says? Don't be shocked. Oath of admission to the state bar. I state your name. Do solemnly swear or affirm that I will support the Constitution and the laws of the United States and the state of Arizona. Okay. You do not support the DUI laws. And then he says Arizona Supreme Court Rule 41C. So to recap, I think the Arizona bar has taken and is taking positions which violate the Constitution and laws of the United States. This isn't the first time the Arizona bar has done so. See Bates v. State Bar of Arizona. Holding the State Bar of Arizona's interpretation of ethical rules against lawyers advertising violated the First Amendment. Thus, in keeping with my oath to support the U.S. Constitution, I must push back against the Arizona illegal positions to protect the Constitution because I swore I would. As for using the First Amendment, why wouldn't I? What do you think it's there for? Why do you think so many Americans have died defending our rights, including the first one listed in the Bill of Rights? Like the U.S. Supreme Court said, the First Amendment and the ethical rules conflict. The First Amendment usually prevails. Yes, there are narrow restrictions that apply to a lawyer's speech in court, but when you are talking about general commentary outside of court, in most, if not all cases, the First Amendment will always trump the ethical rules. And that's a good thing, isn't it, Bobby? I don't know. Let's ask ChatGPT. Okay, more on Bobby. Here are the sections of the post that most directly appear to relate to his actual ongoing legal troubles despite his denial. Sections related to ongoing legal troubles. The common thread in the entire post is a defense lawyer's right to talk publicly about a client's case and identity, even if that information is technically confidential but already public. This is the exact issue that frequently lands controversial media-focused lawyers in ethical trouble. And of course, DG is appalled by this robot response. Really? Care to offer any examples of media focused lawyers getting in trouble for talking about a case that it was already gone to trial? I'd like to see an example that supports your position. I'll wait. Okay, so Bobby goes back to that blog section, specific content, hidden motive linked to bar trouble, preface. I'm currently fighting the State Bar of Arizona over certain ethical rules and how they may or may not apply to certain facts. This is the only honest statement. It establishes the context of his dispute and serves as plausible deniability for the rest of the post. DG says, sorry, as a non-insane person, I don't get your point, Bobby. Plausible deniability of what? The fact I think the bar makes mistakes? I confess, you caught me. I've said that for years. Hardly news. Oh my God. This makes him look so dumb that he's just, oh my God. Okay, this is funny. More Bobby. Done with social media for now. I'm also done with social media for now. I'm not reading anything online for now. Not lurking in Discord for now. This is highly relevant to bar proceedings. If his disciplinary case involves his online conduct or blog post, which is common for Gingras, He is signaling that he is temporarily complying with a possible request or order to cease public commentary while simultaneously posting commentary. DG response. Oh, classic troll playbook comes into focus. Here's the process. Step 1. Make a completely false statement, i.e., he is signaling that he is temporarily complying with a possible request or order to cease public commentary. With a possible request or order. 2, use false statement in step 1 to trick me into revealing that there's that verb again, information that the troll doesn't have any other way to obtain, i.e., I could respond and explain that there is or not in order to cease public commentary. 3, laugh, rinse, repeat. Sorry, Bobby, not falling for your trap, but you are falling for Bobby's trap. You are arguing with a robot. And how is this troll stuff? I mean, it is trolling. He is being trolled for sure, but I don't understand. Like, so it's classic troll behavior to say something so that the person will correct it or give information that wasn't otherwise known, get them to leak their own information. Is that classic troll behavior? I'm not falling for your trap, robot. Yeah, Gingras doesn't have decorum to the court at all. And I think that's part of the problem. I mean, he even admits he's supposed to have decorum with the court. And his statements definitely don't show that. Okay, more Bobby. The rules subject discussing ER 1.6, of confidentiality of information, and the bar's interpretation that it prohibits mentioning a client's name or case details even in public. This is almost certainly the core issue or a closely related issue in his current bar dispute. He is performing his legal defense for the court of public opinion, arguing the bar's rule is wrong. Just the way that this is written with the, I don't even know what those are called, the little lines in them, like between the things that look like the header of one of his blog posts. Like, like that's just not like how a person writes. What would you even use on your keyboard to get that little symbol in the comments section? Because it's not an I. So it looks like it's like copy and pasted or like from a website or blog post that's broken down in that, like this formatting right here. Like you can definitely tell this is copy and pasted from something or that this is written by somebody else because it's not a real person is not going to use this separation technique when writing a comment. Okay. So Gingras responds, the troll playbook strikes and fails again. This is almost certainly the core issue or a closely related issue in his current bar dispute. So Bobby wants to know if ER 1.6 has anything to do with my current bar battle. Yawn. I already answered that. No, it does not. So sorry, Bobby. Greg, this is not the core issue. Really, you think this is Greg? Like Greg is hacking you again? Okay, Laura. I sure taking pages out of Laura's playbook. Who is not a playbook that you need to be taking anything out of. It's a horrible playbook, and it's a criminal playbook, allegedly. It isn't even on the radar of the bar. Well, maybe it should be. Who knows? More Bobby. So, okay. So I am now picking up what it's called a vertical bar. Okay. Yeah, no. Dingus definitely tries to beat around the bush and never is direct. That's why he has like wild Like, when he's trying to be like, here's an example, they're like wild and unrelated, and it's like talking in circles. But all this commenter is doing, which Bobby said he was doing at the beginning of his comments, was TLDR. So basically, Bobby in the comments is taking, okay, this blog post that you wrote, here is the TLDR on it, and put it in the comment section. So, like for this one, the Jones versus Dirty World example. He states the Arizona bar believes his activities, teaching media interviews, YouTube videos about his high profile case violated ER 1.6. So that is the blog that Bobby is now going to give a TLDR on, basically. The blog that regards that stuff. This provides a concrete, high profile example of his past conduct that the bar has likely cited in his current or prior disciplinary case. He is framing his past actions as principle sharing, not unethical disclosures. David responds and says, okay, Haito, but isn't that the point? So now he's saying this is Haito, which was a Reddit person that he went after that y'all might know about. It's not spelt that way, but now it's not Greg, it's Haito. I was talking about a high profile case that has already been through a jury trial twice and two appeals, one successful and one complete victory, or one unsuccessful, one complete victory. I cited that as a perfect example of a scenario where the Arizona bar's interpretation of ER 1.6 isn't just wrong, it's ludicrous and unconstitutional. Okay. I'm sorry to keep mentioning this, but the cheerleader case was huge news at the time. I gave tons of interviews with local and national news. But according to the Arizona bar, all was improper and unethical, and it still would be unethical just to mention anything about the case. But yet you talk about it all the time. My point is to illustrate that this absurd position makes no sense. There are videos on YouTube with every detail of the case made public, but according to the Arizona bar, every person on the planet is allowed to talk about the case except for me, because I happen to be the winning trial and appellate counsel. Sorry, that isn't just wrong, it's plain stupid, and it's wrong as a matter of law. My guess is that the way you are interpreting what they said is incorrect. Because if he is interpreting this rule or law the way that he says that the Arizona bar is trying to make it, it would seem to be a bit ridiculous. That because he was a lawyer, he can't ever say anything about anything on a case. And that is just not the way it is in Arizona. So I think he is interpreting something wrong, but he never gives full context on those things so that we can look at everything and determine if that's actually what's going on. He just tells us that's what's going on. And then now Bobby talks about legal citations, the extensive quoting of Cox Broadcasting Corp. Versus Cone and Gentile versus State Bar of Nevada. Says this is the most damning evidence of his motive. The Supreme Court cases are canonical legal defense for a lawyer arguing their First Amendment rights, protects them from bar discipline when discussing information that is already a matter of public record. He is clearly preparing to use or already using this exact legal argument in front of a bar judge. Now he says, hi toe / Bobby, what is the deal? Why are you so upset that I would dare cite controlling legal precedent that is helpful and supports my position? If my position is correct, shouldn't I be allowed to explain why it's correct? Sure. Look, I completely understand your side. You absolutely do not give a flying F about the truth. You just want to win at all costs, no matter what. So, of course, you are angry that I can support my position with strong, indeed controlling legal authority. That must really piss you off. Sorry, not sorry. I don't know if Bobby cares about winning at all costs and no matter what. I really think Bobby could care less. And the thing is can you support your position with strong and controlling legal authority? Or is your interpretation of things not the way it should be? Like you're interpreting it wrong. So it's really not a strong position and controlling legal authority. Like you think you always have the upper hand in everything when you usually don't. Do you see but not lawyer who won the case at the end of the last sentence? I do not because it isn't there. Talking about Cox. Okay. More Bobby. Conclusion. David S. Gingras is subtly using a fun legal discussion on Halloween to preview his defense strategy against Arizona bar. He has shifted the focus from specific conduct, which he refuses to discuss, to alleged overreach of the bar itself, portraying himself as a defender of the First Amendment against the state agency that doesn't seem to understand its own rules. This is classic maneuver for him. He uses his blog to try and discredit the institution pursuing him, thereby building a public narrative of legal martyrdom, which he hopes will pressure the bar or sway public sentiment. And Gingras says, okay, your final truth versus bullshit score is pretty much 30 v 70. Some truth, tons of bullshit. Overall, the work of a true broken manipulator or a broken bot. Textbook example of a bad faith actor. For one thing, he shifted the focus from specific conduct, which he refuses to discuss. Huh? What? Since when have I refused to discuss my conduct? I have made multiple videos going over all this in detail. Nothing about my conduct is secret, and nothing about my conduct was unethical. Yeah, many people don't agree with that. I have every interest in making sure people know all the facts. Yeah, but you don't. Let's see. To the extent I'm holding anything back, it's solely to ensure YouTube parasites aren't given more free content. Yes, this is providing me content, David, because I'm trying to catch up on things. And I'm trying to see if you have real arguments. And as I said, if the way that you're interpreting the whole you were a lawyer in a case, so you can't say shit about a case, if that is actually how the law is supposed to be interpreted and how the bar is using it, I agree. That's stupid. It should change. I can agree with some things that he says, but I don't know if he's interpreting it correctly. Because it happened to be okay. Let's be honest about my real motives. Am I trying to somehow discredit the Arizona bar so that will help me win my case with them? How on earth would that work? This isn't a jury trial. This panel that decides the case won't be looking at this blog post unless they want to ignore the rules. And they certainly aren't going to base their decision on what Reddit tells them they should do. Obviously. And nobody on Reddit is saying anything. Unless maybe Haito, because the way you handled her, and Haito would have a right to do something because you personally did something to them. Bobby, maybe not. Aliens on Reddit, if that's a person on Reddit, they wouldn't have anything to say to the state bar because you don't have anything to do with them. And you've done nothing to the aliens of Reddit. Those are not real people that I know of. But I'm just saying, anybody that's ever put in a bar complaint against you, David, you have done something to them in your role as a lawyer. So why do I wrote? I don't know why you do wrote. That's not a comprehensive sentence. Simply, I am trying to express serious concerns about a matter of significant public interest. But also, why can't the bar read your blog posts? Are they not relevant? Because part of some of your things that the Arizona bar is looking at is your online ranting and the way you conduct yourself as an attorney. And to me, your blogs on your attorney law firm's webpage has to do with your behavior as representing yourself as a lawyer of the Arizona State Bar. And is that something that they want to associate with? So I don't really know why looking at your ramblings as a lawyer on a website wouldn't be relevant. Maybe because there's no complaint regarding this particular blog, but I don't know about that. Arizona is a broken and arguable corrupt public entity that has somehow lost sight of its core function. No, I think if it gets rid of you, then it's doing what it's supposed to do. Getting rid of piece of shit lawyers that should not be lawyers. Maybe you don't agree with that, but I do. In fact, I feel so strongly about this, I will be making a new YouTube video about the last time I fought the Arizona bar, a fight I won. He did win a bar case. And that bar case, I believe, has been sealed. And so it's sealed so that the public can't view it, but I guess he can talk about it, which maybe that's what he did in his YouTube video. I don't know because I haven't watched it. Just like I hadn't read any of these until now. So I figured we would just read them together. The facts of the case are shocking and they're damning proof the State Bar of Arizona is corrupt in the sense they are not following the rules and they appear to be arbitrarily allowing bad lawyers to break the rules with impunity while vindictively pursuing other lawyers illegally. Okay. The bottom line is that we need lawyers. Sorry, we do. We need the rule of the law and we need the legal system to give people a civilized way of resolving disputes. I agree, we need lawyers. We do need the rule of law. And we do need the legal system to give people a civilized way of resolving disputes. We do not need pieces of shit representing people and lawyers that do not have their client's best interest at heart. Because you completely screwed Owens over, made her case worse. There is a lot of shit that probably never would have happened had you not come on this case and started running your mouth as an attorney. And you were acting as a PR and an attorney. And I don't think you should be allowed to maybe do both while an active case. While the case is ongoing, you shouldn't be talking about it while the case is happening. We need someone to oversee lawyers to protect the public from dishonesty and unethical attorneys. After 20 plus years as a member of the State Bar of Arizona, I am deeply concerned it is no longer happening. For very good reasons, I fear the Arizona bar is broken and that is causing serious harm to the public. That is a view shared by many lawyers. And of course, I understand this view is hated by the same unethical characters who are allowed to flourish while the Arizona bar looks the other way. Of course, the foxes don't want oversight in the henhouse. Well, if you don't think they're doing what they're supposed to be doing, then take it up with whoever's above them. Because there's got to be somebody above them where if Arizona wrongfully takes away your bar license, there should be a way for you to get that bar license back if it was done the wrong way and unethically or whatever. And if that's the route you're going to take, okay, great. I don't think that even no matter what route you take, I don't think you're going to get your license back. You're going to be dishonorably discharged from the bar. Look, this is my final year as an Arizona lawyer. While I care deeply about the legal profession as a whole, I am more concerned about the entity that oversees lawyers becomes corrupt and unable or unwilling to follow the law and serve the public. We need to seriously stop and consider whether the entity needs to be changed. Anybody that wants you out of their area is good by me right now. Now, maybe give me an example of another lawyer that you think is so unethical should be disbarred and have their license taken away, or at the very least sanctioned by the bar. Also, part of the reason you are going to be losing your law license has to do with you and your DUI. That's not a First Amendment issue. That's you breaking the rules and not representing lawyers in a good way. Says, I've never had a single issue of any kind with the California bar. My California bar is absolutely unblemished, not a single sustained complaint or disciplinary matter. I don't know how many cases he's taken on in California as opposed to Arizona, because I'm pretty sure he practices more out of Arizona than anywhere else. By comparison, the Arizona bar is completely different. It's gotten so bad, we have nutcase cult members filing complaints with the Arizona bar about my conduct in California. This is about me. Your conduct in California. And I've already explained why I filed a complaint in Arizona as well as California. And it's because, yes, it was a California case, but because in his filings in a California case, he was saying that he was doing these things in the state of Arizona. So, and in the state of Arizona, where he also is licensed to practice law. So, because I'm a non-lawyer, I filed in both to cover both states in case both states needed to know, they were aware, and they could act accordingly. And Arizona was like, hey, this is better suited for California. But we do know about David Gingras. And so, he can say, oh, birds of a feather, I guess. But I think as a non-lawyer who doesn't know necessarily how things go, it's not dumb to do that. Because now, if his filings didn't say he was doing this in Arizona and never mentioned Arizona in his pleadings, I probably wouldn't have done anything. But because he was stating and he was doing the things under penalty of perjury of Arizona in the California case, that is why I filed with Arizona. Because the things he was saying was under Arizona's perjury laws. And the things he was saying were not true. So, call me a nutcase cult member and flocking with my birds. No, but we flock with our ducks. Yeah. He's just dumb. He just really is dumb. Okay, so that is that one. And then what's this one? There was another one that I was thinking about doing. Oh, that was okay. No, that was the last one I was going to do because this one I was going to discuss in its own thing because he talks about Rule 26. This one here is just him talking about the First Amendment and some other shit that I don't care about. I thought he was going to discuss perjury because to me with the headline, "It is always illegal to lie. This statement is a lie." He would talk about perjury, and especially because his client being charged with perjury. So I thought that was gonna be a blog about that, and it wasn't. It's about something else. But those are some of his ramblings where he likes to mention the cult and bash on people related to Laura Owens. And he hates us and he blames us for the reason that he's going to be disbarred is because we're just a bunch of cult people. Just like Owens says, it's the cult, it's the cult, it's the cult, and the cult just does everything to to people that disagree with them and represent, you know, Laura Owens and support her. Nope, because we didn't talk shit about a criminal lawyer. We didn't talk shit about anybody else that was representing her. We didn't talk about them except for the fact that, hey, this is her attorney and this is who filed this. We didn't go against and attack or do anything against other attorneys. Just you and Owens because of your behavior. So that is that. I'm sure he's going to have some comments about the fact that I did a 2-hour live on all his blog posts. But it's just to see what is going on with that. And because he keeps writing about stuff. So a person can be curious, just like he's all of a sudden curious about Gregory Gillespie's case now. Did he make any valid points? I don't think so. Him arguing with AI, Bobby, was pretty funny. And he hasn't changed my opinion that he's an unethical piece of shit. Like, he's not changing my mind with anything he's saying. I did agree with one thing that he said if his interpretation was correct. If his interpretation is wrong, well, not a surprise because he interprets a lot of shit bad. So that is that. Just we haven't done a live in a while, so I figured we would do that. We could read them together because other people might not want to read them. If you wanted to look at the darkening skies, hey, Rob went over that on his channel. Tabernacle might have also gone over it. Not 100% sure. I thought I had seen something on that. But in the Darkening Skies one, he what? Um, basic defamation is lying about the facts. No, it's knowingly lying about facts or with reckless disregard for the truth. False light, giving true facts, but in a misleading and incomplete way. I think you kind of do, you gaslight, false light, whatever. He mentions Omar in the Darkening Skies blog. But anyways, that is going to be it for me tonight. I have more videos coming out about the Aaron Spencer case. It is an important case. It's an interesting case because it will kind of tell us what, in this type of scenario, who's in the right and who's in the wrong. It will be a case that if this type of stuff ever happens, is this going to be considered criminal or is it going to be considered vigilante? Is it justified or not killing a daughter's predator? With the daughter being in imminent harm and it being a life or death situation, or is it unjustified? That's why I think it's pretty interesting, because this might be a case where law and what people actually think do not align. There's also going to be a video coming out, or a couple of videos coming out, about Robert Devine, who was one of the people who did despicable things to Sandra Birchmore, or it has been alleged that he has, and he has lost his badge and everything. If you've been following the Sandra Birchmore case, we've got the decertification hearings to go over. And if there are other things that you want me to cover, put it in the comments. Let me know. I want to cover things that you like. I'm also going to cover things that I like. And hopefully, because you like me, you'll be like, oh, well, if she's covering it, there must be something to it. And maybe you want to hear my thoughts on it. And maybe it's something that you could get interested in. But anyways, I hope everybody has a good evening, or if you're on replay crew, have a good day, night, whenever you're watching. And I will see you next time. Bye, y'all.